What I really need from my law firm is someone who can provide my staff training so we actually can stay out of trouble.
I really just want somebody who's going to aggressively fight for me in court. Is that too much to ask?
When you have property management problems, we have your solutions. This is the Zona Law Group podcast with the experienced attorneys from Zona Law.
And welcome back to the Zona Law podcast. I am Mark Zinman, joined here today by...
Hi, everybody. Spencer Dickson here.
And if you recall, everybody, from the last time and Spencer was in studio here, we talked a little bit about Spencer's family, Spencer's wife, Allie, the kids, the whole shebang. I figure we might as well surprise you again with something you did not know about Spencer, which is the fact that Spencer is a triathlete on top of being an attorney. So how do you pull that off with your schedule?
Wow, you just run a lot in the morning and don't ever sleep.
Impressively, though, he also swims sometimes during lunch, which to me, I'm like lazy and I'm maybe taking a walk at best, and you're out swimming and crushing the world.
If you ever see me in court with goggle lines around my eyes, that's the reason.
That's how you know we're working hard for you. So we are back here today in studio to talk about non-renewals, which is actually a topic that doesn't get enough coverage as it should. And a client of ours that brought it to us, the idea of really doing a podcast to address it for their managers, so everybody's on the same page. And so the client knows who they are. Shout out to them. We can't, obviously, for ethical reasons, we don't announce clients, but we do appreciate the idea. So for anybody also watching this podcast, any future ideas you have for us for podcasts that you want to see, please let us know. So two things for today. One, it actually has been a while since we've been in the podcast studio, so it's great to be back with you, Spencer.
Thanks for having me back. The first time I was here was my first day on the job, so they haven't got rid of me yet, and I'm glad to be back.
Things are going well. I can't complain on that side. So it's been a while. And then number two, I clearly have forgotten about my barber. I acknowledge that. The hair's all over the place, but that's life. Spencer works out, and I evidently just skip haircuts.
You're looking good, Mark.
Thank you. I need that. So non-renewals. Most people in Arizona, they sign a 1-year lease. At the end of that year lease, the default, most people say, is, hey, let's keep that resident, just renew them for another, so that way we don't have the vacancy. We don't have, trying to go find somebody else, and just to fix up the units. Why would you non-renew somebody, though?
And sure, and like you said, the default is let's carry on. It's easier to retain a tenant than it is to find a new one. But to your point, you might want to non-renew somebody based on a history of delinquent payments. You might want to non-renew somebody based on interactions that they have with other residents, negative interactions with staff in the office, things like that.
So you have pretty much any reason in the world, then you can non-renew somebody, right? Is there anything you can't do?
So you can non-renew somebody for any reason, like we said, or no reason at all, with two main exceptions. And the first is that the reason has to be non-discriminatory. You can't give somebody a notice of non-renewal for a discriminatory reason, some reason that's a person is a member of some protected class.
Right, and so everybody knows from our previous podcast, your protected classes, the main 7, race, color, religion, national origin, sex, familial status, and disability. So even just the last one, right? Like, you're disabled, I won't rent to you. That's clearly discriminatory, or I won't, in this case, non-renew you. So what's the other? So one with discrimination, what's the other reason you can't non-renew somebody?
And the other reason would be retaliation. Now, retaliation is defined in the statute. It's in 33-1381. There are 4 reasons that are defined as retaliation, and they involve a range of issues that some can come up frequently, others they will be less frequent. If a tenant is making a complaint to the landlord about habitability, about a complaint that the landlord failed to fulfill its duties under 33-1324. Another reason would be if the tenant complained to a government organization in charge of either enforcing health codes or complained to a government agency in charge of the Price Wage Stabilization Act. And the fourth reason would be if the tenant joined a tenants union or some similar organization. So those categories, some of which are common, some of which are uncommon, would be a reason that if the tenant did that thing, you could not then go and give them a notice of non-renewal for that reason.
Okay, so basically we can non-renew for any reason under the sun, as long as you're not discriminating and as long as you're not retaliating. And I think what we see a lot of the times is the tenants come in and say, oh, well, you're retaliating against me. But what you're saying is that for it actually to qualify under the statute, it has to hit one of those 4 things.
That's right. And so exactly. And you're going to find that a tenant's going to allege you're discriminating, you're retaliating. So what you need to do, while you don't have to have a reason, you don't need to give the tenant a reason, you should document and you should maintain a record of why you're actually non-renewing them. Because if they say if they allege this is because of discrimination or retaliation, you're going to have to be able to prove, perhaps you'll be able to prove later, no, here are the valid reasons that we non-renewed you.
Okay, so during the tenancy, then what's the best way to do that? If there's issues of, screaming at other neighbors, alleged smoking in the property, just general disturbances, parties all night, like what should managers be doing so that when they get to that non-renewal status point, they're good to go and they have the protection they need?
Right. So you're going to want to be able to document the file, and you're going to want to document an internal file, and you're going to want to have letters and notices that go out to the tenant. So whether you're issuing a 10-day notice of noncompliance, in the mobile home world, you're issuing a 1430 notice of noncompliance. And even if you feel like the behavior, maybe someone comes into the office, blows up in the office, yells at staff, and then leaves, and you think, well, maybe we're not going to do an eviction over this reason, and maybe ordinarily I would feel like I don't want to issue a 10-day notice for this reason. At least send a letter. Send a letter to the tenant, document what happened, let them know the behavior is unacceptable, and then when it comes time for renewal, the tenant should not be surprised if they're getting a notice of non-renewal.
Yeah, and that's what I always tell clients. Like a tenant shouldn't be overly surprised that they got the non-renewal notice. There should be communication along the way that there's a problem, it's not being addressed, there's repeated instances of different issues. If there's been no communication and no issues along the way that the tenant's been put on notice of, you can almost always assume the tenant's going to claim that they're being discriminated against or they're being retaliated. So you need to have some sort of documentation along the way to really help provide that documentation to your resident and then to cover yourself on the backside as well. So let's say you get to that point and you're like, okay, we've had the constant problems. We've sent out 10 days. We've sent out courtesy notices. We decided not to evict, but we do want to non-renew. So what's the process to non-renew? How much notice should be given to the residents?
Right. So you're going to want to look to the specifics of the lease. Some leases say you might even need to give 60 days notice before the end of that lease in order to non-renew somebody. Sometimes the lease will say 30 days notice. If you're ever in a situation where the natural term of the lease has ended and you're in a month-to-month situation, you're going to need to give 30 days notice prior to the expiration of that lease. Now, when we say give 30 days notice in advance, if you're going to be sending that letter, that notice via certified mail, you need to add 5 days to that time period. And there's really no harm in being earlier than that 35-day window. So if you want a calendar so that you're, 40 days, 45 days before the end of the lease, just so that you make sure you have time for the mail to arrive and you have time for the 30 days to kick in, it'd be wise to get that calendared well in advance.
Yeah, and I think it's really important to realize with that, what Spencer's saying with that 60 or 30-day notice, looking at your lease, especially in the multifamily world, we realize management changes a lot. So you may be managing a property that's not the standard lease for your company. And it's possible that that lease requires a 60-day notice where you're just used to doing a 30. So we always suggest go to that residence lease, check what the applicable notice provision is, add the 5 days on for mailing just as a default. Just know you're going 65 days if it's applicable, 35 days, whatever it is, and send out the notice. Now, the next question, of course, is you send out this non-renewal. You know the first thing that's going to happen, that resident's going to come into the office and say, why'd you non-renew me? What's the appropriate response?
Right. We don't recommend that you get into the specifics of the reasons for the non-renewal with the tenants, right? You ought to have the reasons. You probably have communicated some of the difficulties in the past with the tenant. But when the tenant approaches you and says, hey, why'd you do this? The best response we feel is you tell them it's a business decision. We've decided to non-renew you. We just made the business decision to non-renew. You don't go into the details. You don't go into the specifics, although you do have those in your records.
Yeah, and the reason that is because if the tenant comes in and asks, why'd you do this? If you start going through the factual history of, well, on this day this happened, and this day this happened, and that's the basis for your non-renewal, most people are going to start fighting that. Well, no, you took that out of context, or you did this. It's not really an option. You're not asking for their input. You're simply just non-renewing them. And it's important to remember, a resident has that same right as well. A resident can non-renew their lease at any point, and the landlord can't go to them and mandate that they stay. Either party can terminate. It's just a done deal. Now, so what happens is, if they fail to vacate, you would have to file an eviction. And in that eviction is where they would potentially claim the retaliation or the discrimination. And that's where you need the documentation you're talking about, right, Spencer?
That's right. And so we just had a case where a tenant claimed that a non-renewal eviction was for a discriminatory and retaliatory purpose. And part of preparing for that case was going through with the client and looking at the history of the tenant, looking through how the tenant failed to live up to the terms of the lease throughout the term of the lease, and what the defects with the tenancy were as we went along. So that documentation was very important in pursuing an eviction action. In another type of case, you may have a claim for discrimination, a fair housing case that comes up where someone is complaining to a government agency that they've been discriminated against. You're going to want to have that same documentation. That your response to the government agency who is charging you with discrimination is, no, look, here's the non-discriminatory reasons that we non-renewed this person.
Yeah, it's interesting. It's such a jump because when you have that first communication with the resident, you just simply say, it's a business decision. I'm sorry, that's it. But then if you get the fair housing complaint, if you get into the eviction, that's where you go into the detailed documentation that you have from the full file. So the default, again, like Spencer said, frankly, I think you said that excellently, right? It's cheaper, it's better to keep a resident than you have than to go try and find a new resident. I think you said it more eloquently than me, though.
I think you said it best, Mark.
No, again, going back to the triathlon, you probably run better than I do as well.
Wow.
So that's there's no question there. But you guys have a right, for whatever reason you want to non-renew somebody, as long as you're not discriminating, as long as you're not retaliating. Our advice is simply make sure you document the file along the way and send those communications as well to the resident. But until next time, please like and subscribe to the YouTube channel, to our podcast, and we'll see you next time at the Zona Law Podcast.